नमस्ते. Today I'm going to tell you how to file a check bounce case. यह वीडियो हिंदी में भी रिकॉर्ड किया गया है और अगर आपको यह वीडियो हिंदी में देखना है तो नीचे दिए गए डिस्क्रिप्शन बॉक्स में लिंक पे क्लिक कर सकते हैं. All of us are already aware what a check is and we have been using it in our daily lives. What would happen if the check that you have deposited in a bank bounces? What would be your remedy? In order to know that and understand the procedure and the law behind the check bounce, we need to understand the three parties that are involved in a check bounce case. The first party is the payee, that is the person to whom the check is addressed. The second party is the drawee, that is the bank on whom the order is made to make the payment to the payee. And the third party is the drawer, that is the party which is making the payment, that is the signatory of the check. So in short, the drawer directs the drawee, that is his bank, and makes an order that please pay XYZ amount to the payee. Let us presume that on the 1st of January 2020, I give you a check and you present it on the 10th of January in your bank. On the 12th of January, the bank informs you that that check has bounced. So when the bank informs you that the check has bounced, it will also issue a return memo. The return memo contains the details of the check along with the reason why the check has bounced. The reason may be either stoppage of funds, account closure, signature mismatch, and there are a variety of reasons due to which a particular check can bounce. So what would be your remedy against such bounce of the check, that is the return or the dishonor of the check? So the first and foremost step or advice that I'm going to tell you, it's going to be a very obvious one. You just have to simply contact the drawer of the check, that is you have to contact me, and you have to just tell me that such and such check number has bounced and kindly make good the payment in the next 2 to 3 days. Now the reason why I have given such a short period of 2 to 3 days would be evident in the coming few minutes of this video. If supposedly I do not return your calls or I am reluctant to pay you the amount or I am not very eager to pay you the amount and you feel that there is something fishy going on, then obviously you can approach, you can try and approach a lawyer or you could avail your legal remedies. So once you feel that I am not paying you the amount, you can send in a demand notice or a legal notice which is drafted by a lawyer within 30 days from the date on which you had received the return memo from the bank. So since you had received the return memo on the 12th of January, you can send the legal notice or the demand notice within 30 days to me, in which you have to specifically claim that you had presented the check within 3 months validity period, that is the 3 months from the date on which the check was drawn. Secondly, you have to say that you are sending the legal notice within the 30 days or the demand notice within the 30 days time period as is prescribed in the law. Thirdly, you will be saying that it's a very important point. You will be saying that the check was bounced due to such and such reason, and the check that you had issued to me was in discharge of some legally enforceable amount or some legally enforceable debt. Now, what is a legally enforceable amount or a legally enforceable debt? So, for example, if I purchase a mobile phone of, let us say, rupees 10,000 and I go and issue a check to the shopkeeper and the mobile phone and the check does not clear. So, that would be a legally enforceable debt as the shopkeeper has a legal remedy against me. However, if I supposedly am betting in the cricket match and I owe the bookie an amount of, let us say, rupees 10,000. So and I issue a check with respect to that amount. So in that particular circumstance, it will not be a legally enforceable amount as it's not a legal transaction that I'm doing, and accordingly an offence under section 138 of the Negotiable Instruments Act will not be made out. Further, another point that you have to mention in the legal notice is that you will be giving a time period of 15 days to the drawer to make good the payment. Else, you have to specifically write that you would be pursuing your legal remedies under the law. Now, why I had asked you initially to give him a time period of 2 to 3 days is because the procedure and the timeline of a check bounce case is very stringent. You have to follow all the timelines. So you have to send the legal notice within 30 days from the date on which you had received the return memo. Let us presume that the check that I had given to you dated 1st of January 2020, its validity will be for 3 months. So, and you got the return memo on the 12th of January. Now, it's so happened that you were not able to send the legal notice to me within the 30-day time period calculated from the 12th of January. So, what is your remedy in that particular case? You can represent the check in the bank, let the check bounce once again. Within 3 months, you can present it again and again. And again, when the bank provides you with a return memo, that is when you can definitely send me a legal notice. If you send me a legal notice after the 30-day period has expired, it will not be considered a good legal notice and you will not be having a good case against me. And an offence under section 138 would not be maintainable as the timeline of 30 days has not been adhered to. Now, once we have sent the notice to the drawer, that is, if you send the notice to me, you should make sure that you keep a copy of the legal notice with you, and also you make sure to keep the receipt of the speed post or the registered post by which you have sent the legal notice to me. The receipt will help you in determining on what particular date you had I had or the drawer had received the legal notice, and from that particular day, let us presume that I received the legal notice on the 1st of February 2020. So from 1st of February 2020, I will be having 15 days time to make good the payment to you or to reply to your legal notice. Whether I reply to a legal notice or not, it is immaterial, as the drawer of the check has to uh, pay you the amount within the 15 days stipulated time period. Now let us suppose that it's the 17th of February, 15 days have lapsed since the legal notice was sent to the drawer, and that is me in this particular example, and I have still not paid the amount to you that was there in the check. So in that particular circumstance, you should go to the honorable court and file a criminal case against me under section 138. Please note that that the nature of section 138 of the Negotiable Instruments Act 1881 is that of a criminal nature. Now, the reason of giving a criminal nature to such a provision in the Act is that the general public should be respecting the transactions that it is making by way of checks, and everyone should respect the check that one person is issuing to the other person and should not be taking it lightly. So it's just to give a sense of trust to the person who's receiving the check, that in case there is a default, then the issuer, the drawer of the check, can be sent behind the bars. Now, a check bounce case under section 138 of the Negotiable Instruments Act is filed before the judicial magistrate of first class if you're staying in a non-metropolitan area, or in the court of the metropolitan magistrate if you're staying in a metropolitan area. Now, metropolitan area has been defined under the CRPC, and you can have a look at it. Now, we know that we have to go and file the case before either the JMFC, that is the Judicial Magistrate of First Class, or the Metropolitan Magistrate, which is a criminal court. But in what territorial jurisdiction do we have to file the particular case? Since it's a criminal matter, therefore there is no pecuniary jurisdiction that is to be seen into. Pecuniary jurisdiction means the value of the transaction or the value of the check that we are filing a case for. But since it's a criminal matter, as I just said, there is no requirement to look into the pecuniary jurisdiction, and the territorial jurisdiction will be ascertained by the following 4 points. So the place where I had drawn the check, or the bank on which I had drawn the check, would be relevant. Secondly, the presentation of the check, wherever you are presenting the check in your bank for clearing, you giving depositing in your bank. Thirdly, the returning of the check. So this is relevant for cross state or inter-district transactions, wherein let us say that I gave you a check in Bombay and you gave it for clearing in Delhi. It's a very hypothetical example, and the check went to Chennai for clearing. So in that particular circumstance, you receive the return memo from Chennai branch, and you can go and file a case over there also. And the fourth way to assess your territorial jurisdiction of a particular court where you can file the check bounce case is the from where you send the legal notice or the demand notice, or directing the or asking the drawer of the check to pay the amount within 15 days time period. Now, we need to look into the punishment of the Section 138 of the Negotiable Instruments Act, and it is punishable up to 2 years with monetary penalty, which is up to twice the amount of the check. So, supposedly there was a check of rupees 10,000, and the maximum penalty that can be imposed in such a scenario is that of 20,000. Now, it's to be kept in mind that it can be either punishment or monetary penalty or both. So the Honorable Court can grant either of the two, either the penalty or the punishment in a case in case the drawer of the check is convicted. Now, an important point that's to be kept in mind is that an offence under Section 138 of the Negotiable Instruments Act is of a compoundable nature. Now, what does a compoundable offence means? And a compoundable offence means that particular offence which can be settled outside the court. So it's important to note that supposedly if the accused comes, the drawer of the check, that is the accused comes and he tells you that, okay, I was to pay you 10,000 rupees. Let us say I will pay you 12,000 rupees, including the cost of the legal expenses and all, or maybe I pay you 9,000, whatever is the mutual understanding, and please take back your case. So you can take back the case by just informing the Honorable Court, whereas in non-compoundable cases, you have to go and approach the Honorable High Court under its jurisdiction that is vested under Section 482 of the CRPC. How would you draft your criminal complaint would be the next question in your mind. So I must tell you that a criminal complaint would be more or less similar to your legal notice, wherein you have to state the transaction that had happened. So for example, if you purchase a mobile phone of rupees 10,000 from me and you give me a check in return of the mobile phone and the check bounces, so I'll be stating in the particular complaint that XYZ person had purchased a mobile phone from me on such and such date, and the bill number is so and so, which is attached here with, and accordingly there was a check given by that person to me, and he had promised that the check would clear within 2 or 3 days whenever I presented in the bank, and trusting him, I had given him the mobile phone. Now the check has bounced. I have called him up several times. Despite that, he is reluctant to pay the amount, and I have sent in the legal, and accordingly it is pertinent to mention that I had even I had even presented the check before the bank within the 3 months time period, validity period of 3 months, and after which I had even sent a legal notice to the accused person and to the drawer of the check, but he has failed to reply, or he has replied denying his liability, whatever the case may be, and therefore there is a and he also did not pay the amount within the time period of 15 days. Thereafter, you have to mention, you have to clearly specifically mention that it was for a legally enforceable debt that you already explained before. You explained the transaction before, and then you can go on and explain you can attach the speed post tracker notice and the receipt of the same, and you can say that he is liable under the Section 138 of the Act, and if you may so please, then you can even club Section 138 complaint along with a complaint under Section 420, and it's totally on the discretion of the Honorable Court whether to entertain both of the offences under Section 138 of the Negotiable Instruments Act and Section 420 of the IPC, that is section of cheating, and or either of the one, and accordingly the court may decide it. Now, since we've already looked into the fact that how a complaint and a notice is to be sent to the drawer of the check in case the check bounces, so this is a very important amendment that happened just recently, and Section 143A was added to the Negotiable Instruments Act, as well as Section 148A. Now, Section 143A of the Negotiable Instruments Act provides for interim compensation up to rupees 20% of the check amount to be paid by the drawer of the check, that is the accused. Now, for example, if your case is a summary trial or summons case, and the drawer does not plead guilty to the accusation made in the complaint, or secondly, if the case is upon the stage of framing of charges, then in that particular circumstance, if the court may so please that there is a clear cut that a prima facie case is made out against the accused person, it may order the accused to pay you 20%, up to 20% of interim compensation of the check amount. And what is to be noted is that supposedly you lose the case and the accused wins the case. So in that particular circumstance, you will have to return the interim compensation that you had so received previously. Now let us presume that if the accused is convicted of the offense and he goes into appeal, and he goes to the higher court in appeal, and if the higher court feels that there is a prima facie case, then it may also direct the accused to pay the amount up to 20% interim compensation of the check amount to the payee, that is you, to the complainant. And in both the cases, that is the case in which a complaint is going on and in the appellate stage, the amount is to be paid within the time period of 60 days. Now, another important point may be that you have to adhere with the timeline of a check bounce case. Now, the timeline of a check bounce case is very important in such matters. Like I've already told you, you have to firstly present the check within the 3 months validity period. That is 3 months from the date of the check. Secondly, you have to send a legal notice or a demand notice within 30 days from the date of receipt of the return memo from the bank. And once you've done so, then you have in the legal notice, you have to provide a time period of 15 days from which the accused or the drawer of the check receives the legal notice, and you have to provide him with a time period of 15 days. In case the accused fails to pay the amount within 15 days, you have a time period of 30 days from the expiry of 15 days to file the complaint before the honorable court. An important point to be noted in such matters is that since it's a criminal offense, so most of the matters try getting settled at the stage of a legal notice. So you should always adhere with the timelines, and you should not be having a lackadaisical attitude in dealing such matters. If in case you miss out on any of the timelines, like I've previously told you, there will be no leniency of any sort. And if the check is still in the 3 months validity period, you will have to go through the whole process again. So let us presume that you had presented the check on the 1st of, I had given you a check of the 1st of January, you presented it on the 5th of January, and you sent him the legal notice by the 10th of January. Now, and he receives it on the 15th of January. So 15 days from the 15th of January would complete on the 30th of January. And if you don't file your complaint by perhaps the 2nd of March, computing 30 days from the 30th of January, or 1st or 2nd of March, and you don't file the complaint within this 30-day time period, you will still be having an option to represent your check in the bank and let it bounce once again, and thereafter you can again go and follow the same procedure. You'll have to send him a legal notice once again, 15 days time period from the date on which the legal notice was received, and 30 days time period will be calculated when the 15 days time period given to him to pay the amount has expired. And that is how you will be going and fighting a case. Since it's a criminal case, most of the matters are settled in such matters if the party is a genuine party, and if not, the matters go on, and they are usually finished very quickly. And if you are having a good case, you would get a nice remedy. You would get up to 2 times the amount. You would also be getting 20% interim compensation if a prima facie case is made out, and also the accused can be sent to jail. So usually they are afraid in such kind of matters, and they try paying the whole amount, or they try settling somewhere, some lesser amount or more amount, whatever may be the case. So this is it's a small step that I'm making this video. It's a small step towards legal literacy. In case you wish to view this video in Hindi, you can click on the link given in the description box below. Namaste, Jai Hind, Vande Mataram.